Steve Brannick of Brannick, Berman and Sider, representing the appellant O'Doyle Rules. We're appealing from the trial court's refusal to allow O'Doyle Rules to file a second amended complaint. The trial court dismissed the case instead with prejudice, accepting the appellee's argument that the issue O'Doyle attempted to raise in the second amended complaint was barred by the law of the case in this court's previous opinion. So the question before the court is, how do we apply the doctrine of law of the case to this court's prior opinion? Here's what I think the essence of the case is. Just putting it very
the author here with you so you can talk to him directly.
I noticed that. And maybe all will be revealed during the course of the argument. But as far as I can see, the essence of the case is the first time around, this case presented two basic issues. One was a right of first refusal issue, and the other was a very briefly argued assignment issue. This court's opinion resolved the right of first refusal issue, but didn't say a word about the assignment issue. So the practical issue is the assignment issue still alive? The black letter law is simple, and I think answers the question for the court. It's the Giuliano case that both parties have cited in their briefs. Giuliano tells us and explains the doctrine of law of the case. It says that issues decided in an opinion govern the remainder of the case, but it's only governed by what is actually decided in the opinion, distinguishing the doctrine from res judicata, where it's much broader and it applies to everything that was argued and could have been argued. So Giuliano tells us that it is possible that an issue could be implicitly decided, but only if it was absolutely necessary to decide that issue to resolve the appeal. And simply put, the assignment issue was not necessary to resolve the appeal, so it wasn't implicitly decided, and that's not law of the case. I came to this case fresh, looking at the briefs, and I found it confusing in reading the briefs to determine exactly what was argued and when. So I thought it would be useful for me to spend just a couple of minutes walking through the court, the history of the case. So O'Doyle,
can I interject for you that, and then my colleagues can ask you to get back on your track of your officiating, but I trust that they're prepared because they always are. You say it was not necessary.
Right.
The assignment argument is not necessary to the resolution of briefs. And I'm just not putting words in your mouth. So one way to articulate that would be that because it would be a cause of action based on a document that wasn't an issue. The document issue was the sales contract.
Sure.
In the sales contract, the performance obligation was contingent on the Seth waiver of the right of first refusal. So this other theory presumably is based on another agreement. And so that's one way in which you could argue potentially, if there's a counter argument, that it wasn't necessary. But I have a question about that other agreement. Why didn't your articulation of that supposed agreement ever make it into the record in this case? Your amended complaint. Is that, we don't even know where is that agreement made, is that premised on a writing? Is that assignment premised on some sort of implication from the facts? Is it sort of an assignment by innuendo? We don't know, because your supposed amended complaint never made it in, not yours, but the counsel's amended complaint did not make it into the record.
right. And it didn't make it into the record because opposing counsel short-circuited the process by telling the court you should rule as a matter of law that the assignment issue is part of the law of the case.
Ultimately, your client, and you know you weren't trial counsel, but your client filed a motion for rehearing, and you've been a civil practitioner for a long time. When you get to that posture, what are you going to do? You're going to file the proposed amended complaint and whatever evidence of this assignment you have at hand. I'm scratching my head on this record and with this level of litigation and the skill of the lawyers involved, why that didn't happen. Because if you had that, then we would have something to talk about on the propriety of the trial judge's denial of leave to amend or failure to grant it. But the record's not set for that. And we can talk about law of the case all day long, and I think that you probably would have to agree that there's at least something to talk about for your opponent. He's going to tell us about it in a few minutes. But ultimately, I think your case on the propriety of whether you should have been allowed to amend or not, it sort of sits at your feet. Help me out with that.
Right. Well, I mean, I teach a course on preservation of error, and certainly the best practice in this case would have been to proffer that amended complaint. But I also teach, when I teach that course, that you can preserve error in lots of different ways. The best proffer is always giving the document to the court, but error can be preserved by a written or by an oral or written description of the case that you're going to bring, and
So
at the
if
hearing.
if you preserve the error, presumably the error is denial of right to amend. And you're saying that legally speaking, or, analytically speaking, is because it was premised on the law of the case, which you're saying doesn't apply. So, so we read what was argued in the court, and what about the argument that it was futile? So there would be a tipsy coachman argument, or if that's necessary to call it a tipsy coachman argument, that said, well, this cause of action would be futile because.
Right. And that's where I was going with the beginning of this argument. They argued that it was futile because it was barred by the law of the case, and we
No,
disagree with that.
I'm making a distinction, futile because the claim could not be stated. Based on the explanation of counsel who orally tried to move to, I guess, amend for the third time, if that's the case.
Well, I mean, it's a pretty simple theory. The theory is that there has been an assignment. You're right, we don't know, is it a de facto assignment? Is it an assignment in the record? But broadly speaking, there was an assignment.
There was actually an averment by counsel that there was a document in which SunTrust assigned its rights under the lease, which prohibits assignments to O'Doyle. But that's not what was said. So you say it's simple, but it's a little confusing because I don't know how that would affect you.
Well, a couple of points there.
Okay.
One, that lease did not prohibit an assignment. It says that the lease can be assigned, including the right of first refusal, with the consent of the other side, and that consent can't be unreasonably withheld. So there's certainly something to litigate there about whether there's consent or not. So in terms of that part of the case, I think it's pretty clear that we don't know yet whether they're going to have success on this argument.
So the other side is the land, the owner of the building, the other side of the lease,
trust,
the
yes.
tenant.
The seller.
And was there, and so in counsel's averment, was there anything stated about the granting of consent? In other words, you're saying preservation, the argument's preserved, and how, maybe that's a question to ask you. How much needs to be preserved for us to assign error here? What is the error? Is the error denial of the right to amend? Is the error, and this is not cert, so we can't say, oh, well, you applied the wrong law, it's not the law of the case. It's, what, was there an abuse of discretion, I think is the standard review for denial of amendment. So if that's the error, do we need to know, don't we need to know the gravamen and a little bit of the details of the cause of action to know whether it's justifiably affirmed on, on the fact that it might be futile?
I would agree with you, but for the fact that at that hearing, opposing counsel argued, Judge, don't listen to this assignment theory. It's barred by the law of the case. He finishes, and before his voice even, stops echoing in the room, the court says, this case is dismissed with prejudice. That short-circuited any opportunity for our client to drill down and answer some of the questions that your Honor
client,
asked me now.
you can see from the hearing transcript on the motion to dismiss that your opposing counsel, your opponent, argued that the assignment could not have happened. There is no, effectively, I'm looking at some page in the transcript, that there could not, that the de facto assignment was located in the prior case, and then he says that Mr. King is actually going to say there's a written assignment, and it will be the first time I've ever seen it. And I can just represent to the court that SunTrust has terminated the purchase contract that it had with the trust. So why not deal with that in the motion for rehearing?
It would have been a better practice to do so, but I think there is enough in this record to preserve the issue. You've said two things. One, you said is, it could be that there's an actual piece of paper that says we hereby assign, or it could be a de facto assignment. And Your Honor, in your question said that de facto assignment was already litigated. It wasn't
I
already
didn't say
litigated.
that, your opponent said that.
Right.
I mean,
But in our,
we can find out easily enough, and it can be shown to us easily enough. what was litigated in the prior appeal. But I don't think the form of the assignment is a major issue here. I think the question is what happened at the time the trial judge ruled, and I think it's maybe a little too cute by half to say, well, the trial judge snap ruled on dismissal, so we abandoned and just focused on law of the case, to then bring the error to us in the alternative as, you know, if law of the case doesn't, if our view of law of the case doesn't work, then we got the trial judge on abuse of discretion in failing to allow an amendment. We didn't abuse the privilege, it wasn't futile, blah, blah, blah. But if preservation means different things in different contexts, I appreciate that. I think I've taken your class on preservation. But I just question how with this record, assuming we don't necessarily agree with your legal interpretation of law of the case, how we could find a reversible error in the amendment. And there, you know, this is tangential, but it boggles my mind that your predecessor counsel had the benefit of 2 or 3 months notice in advance of this hearing and didn't figure out until he got there that he had filed something other than what he thought he was traveling on. When was the last time you went to a hearing without looking at the document you were traveling on before you got here?
No, it's not like it was a week. This was several months ago, and apparently the council showed up at the hearing and said, oh my goodness, this isn't what I thought it was, I need more time. And the judge is sitting there after 20 months saying, now pleading the same thing you pled back then, so, sorry.
And wouldn't the motion to dismiss have called the problem to the attention of the lawyer who filed the available complaint?
Well, I mean, not necessarily. I don't know exactly what happened, but my speculation of what happened is you have a document on your desk that you think is the document that was filed. The motion to dismiss comes
We
in.
all prepared for a hearing like this.
Right.
You gen out piles of binders, telephone books of everything that's been in the court file, and the lawyer who's going to track down to the courthouse carries that with them, in addition to the ones that the lawyer signed off on a letter sending to the judge. And you're saying that he never bothered to read the motion to dismiss or the pleading that he's traveling on until he's sitting in the hearing? I mean, I guess that could happen, and it's not what I would expect of the lawyers involved, but it's troublesome.
Well, from a legal standpoint, it provides cover for the judge, whether they were really out of line based on what was in front of the judge. Whether his discretion was being abused, given what was in front of him.
But I think we need to focus here on what the judge ruled, because that's what's in front of this court right now. The judge never got to any of these discretionary arguments about whether you should have been more prepared at the hearing, whether this is too
So
late.
you're abandoning the argument that you've made on the reversible error in connection to the inability to amend? Because I think you did argue that.
Right. There are 2 parts to my argument. The primary part of my argument is that the trial judge ruled that this case had to be dismissed with prejudice because this assignment issue was barred by the law of the case. We think that's absolutely wrong. And if you look at the run-up to the first appeal, you will see that the assignment issue wasn't properly before the court. And that's
Why wasn't the assignment issue probably before the court?
because,
Brief, right?
well, here, could I just take 2 seconds to run through? So we have the complaint. The complaint raises a right of first refusal issue, doesn't say a word about assignment. Then we have our side's motion for summary judgment. It's based entirely on the right of first refusal issue, doesn't say a word about the assignment. We then get to the summary judgment hearing, and our side argues the right of first refusal issue, but also for the first time then says, oh, by the way, there's a de facto assignment. The other side gets up and, not surprisingly, in connection with the de facto assignment, says, wait a second, there's no record on this de facto assignment. This wasn't part of the motion for summary judgment. None of this is properly before the court. The judge then rules our way on the summary judgment, ruling on the right of first refusal issue, doesn't say a word about the assignment. It goes up in front of this court. They file a 51-page brief, which is in the record. Our briefs aren't in the record, but they file a 51-page brief. It's got one sentence in the fact on the assignment issue, and then has 2 pages in the argument on the assignment issue. One, and they make 2 broad points. Their first broad point is this isn't properly in front of the court because it was raised too late at the summary judgment hearing. Second issue was a very brief discussion of the assignment issue on the merits. Then your opinion, Your Honor's opinion comes out, and it rules on the right of first refusal issue. It doesn't say a word about the assignment. So why doesn't it say?
Just 5 minutes, but I'll let you answer.
You can answer this on any time, but you understand that the presumption, once we dispose of the case with the written opinion, is that we reviewed all the points and
Of course.
determined that only those that are meritorious weren't a written opinion. And you're going to have to pick multiple bases to reverse or say, go the trial just got this part right, but we're reversing on this ground. That's not how this works. And I think you're asking us to look at it through a slightly different lens, save your time up front.
I'm asking you to look at it through the lens that Giuliano tells us to look at it, which is you have to determine, was the assignment issue necessary to resolve that first appeal? In that first appeal, we had gotten summary judgment, and they were saying summary judgment was improper. All you have to do to reverse is reverse on the right of first refusal issue. On the assignment issue, you could have ruled in 2 different ways. You could have said, we don't buy it on the merits. You didn't say that. Or you could say,
We did because we didn't write about it.
or you could have said, this wasn't properly before the court, so there is no basis for granting summary judgment on the basis of an assignment issue that wasn't raised until the hearing on the motion for summary judgment, so that's not properly before the court. Giuliano tells us the only time that you decide something has been implicitly decided for the purposes of law of the case is if it has to have been decided in order to resolve the appeal. And my point is, it didn't have to be decided to resolve the appeal. And I'll reserve the rest of my time.
If it please the court, my name is Todd Hepker. I represent the Applees, James A. Friedberg and Samuel Israel, who are the co-trustees of the Irvin and Suzanne Bard Family Trust, which I'll call the trust during my presentation. We request that you affirm the trial court's ruling and its order dismissing the amended complaint with prejudice and denying Doyle's or Tennis motion to amend. You know, I know your honors know, I have been here throughout this case. I have the perspective of actually being at the hearings, writing the briefs, and I think the facts are important. Mr. Brannick tried to go through. I think there's some facts that maybe he didn't think were important that I think are important, and I'm going to focus on your last round of questioning of Mr. Brannick.
Mr. Brannick mentioned the 2 pages in the brief. I'll admit it escapes me, but I bet in those 2 pages, one of the arguments was that the motion, that the assignment issue was not at issue in the summary judgment motion. And so if summary judgment was granted on the complaint, which didn't mention assignment issue, let's say that the court denied summary judgment. Correct. Why couldn't they amend, at that time, the case would still be ongoing, why couldn't they amend to add this assignment?
Well, they could if the summary judgment hadn't.
Right, so then when it's on appeal, then why is it necessary, why was it necessary in the recorded opinion that we're talking about for the assignment issue to have been resolved in order to resolve the appeal?
Well, because that was a ground for affirmance. If you affirmed, you could have agreed with
That's
that.
the question, couldn't we have?
Well, you had to necessarily reject that argument, the de facto assignment argument that,
But not on the merits.
well, I argue.
You could say, yeah, the trial court was improvidently granted summary judgment based on a totally different theory, right, than the assignment, and then reverse. But what does that have to do with an alternative theory We're reversing summary judgment granted in favor of, make sure I'm not turning around in my own head, Odilo rules, right? Yeah, and then, but why does that necessarily have anything to do with the assignment?
Well, my initial brief is in the record. I argued again, as you know, that we were ambushed at the summary judgment hearing, number one. And then I also outlined very extensively in my initial brief, and it was responded to by O'Doyle in its answer brief, and I responded to that in my reply brief substantively on the merits that the assignment theory does not work.
Different ways, so
Sure.
see if I can understand what your point is to Mr. Granick's sort of last point, which
Yes.
is I think what you're trying to address. The principle that every case comes to this court with is that the decision is presumed correct, and that if there's any basis in the record to support affirmance, we should apply that and follow that rule, right?
Yes.
And so if I'm understanding you correctly, let me just sort of take this to a hypothetical, what you're saying is the way the case came up to us was with two arguments for affirmance by your opponent, right? The
Yes.
business of the right of first refusal and the right of the assignment. And we agreed with your opponent under, I think, this construct, that the assignment didn't warrant reversal. But we agreed with your opponent that the right of first we agreed with you that the right of first refusal did warrant reversal. Is that what, and I'm sorry to give you a Tourette's-ish hypothetical, but I'm trying to understand what precisely is your response?
My argument, my position is that you did necessarily reject the de facto assignment argument because it was a ground you could have used for affirmance. And I actually watched the video, the first argument, oral argument that I argued was on video. It was Judge Northcutt was the chief judge, and Judge Stargell was on the panel, and Judge Atkinson was on the panel. Though that de facto assignment argument was discussed at the oral argument on the first appeal. Judge Atkinson asked Mr. Koenig questions about that alternative theory, I call it. Judge Stargell did. If it's talked about, if it's argued at the summary judgment hearing, it's argued, and after summary judgment was granted, and I argued against it in the motion for a hearing. It was in the initial brief, it was in the answer brief, it was in the reply brief, and it was discussed at oral argument, and questions were asked.
I'm gonna presume Mr. Brandon's gonna stand up and say, it could have supported affirmance for two different reasons, right? Isn't that right? So it could, or it didn't support affirmance. It could have, the conclusion that it didn't support affirmance could be for two separate reasons. One would be on the merits.
And one would be ambush, I guess.
Ambush, or just the fact that ambush is one way to put it, but you can't grant summary judgment on a complaint that doesn't include the theory on which you're seeking summary judgment.
But my point is
So
that
my point is, if we reverse on that latter rationale, then why couldn't go back to trial court and the party, the plaintiff rectify the problem, which is, oh yeah, we didn't plead this. Let's move to amend and plead it now. Why not? Why the wrong case? Why was it necessary to resolve on the merits?
well, the question is, in the prior opinion, and I couldn't tell from what happened at the oral argument what this court thought about that, other than it had to have been rejected and had to have been necessarily decided, or you would have affirmed on that basis.
Let me ask this, if their opinion had said, you know, we summary judgment was improvidently granted based on the theory that that the right of refusal survived the sales contract survived the failure to waive right of refusal. And we now turn our attention to this alternative theory. That wasn't pled, therefore it does not serve as an alternative theory for affirmance because it wasn't pled, and then reverse. Are you saying then that the plaintiff could not, that the plaintiff has just to take its ball and go home and can't amend to,
I think that would be a more procedural type thing and make the argument better, but I still don't think that it means.
the opinion said that, you're saying a plaintiff could not amend to amend the complaint. In other words, you won on summary judgment, we reversed your victory in summary judgment because one alternative theory that you raised was not pled in the complaint. All we did was reverse summary judgment. The case, is not closed out. You're saying that the plaintiff doesn't have the right to amend, to add the theory that they failed to plead in the first place.
I think if it had gone to that, Your Honor, the argument would be better for them, that they could actually say that the de facto assignment theory.
They filed a proposed amended complaint and fleshed out the assignment?
Yes, and I also want to make.
No, wait a minute, I want to ask a follow-up to your question. I took what you meant was if it had gone to that, my hypothetical, which is if we had gone to that, if the opposed opinion had gone to that, it would have been different.
Well,
The opinion said, here's the deal. The grounds on which some of the grant was erroneous. The alternative grounds could not have justified summary judgment because it wasn't pled, reversed. And you're saying then they would have had a better argument about their entitlement to amend, to add that previously unpled theory.
That is correct. If this court would have utilized, I keep calling it the ambush argument. If this court had actually come out and said, we're going to reverse the summary judgment that was given to O'Doyle because of the ambush, because it wasn't pled before the summary judgment hearing, their argument would be better. I also want to go to another point that I made in my brief. I argue that the Ortenta's motion to amend, that the second amended complaint that he was proposing and described at the motion to dismiss hearing was insufficiently pled, and that's another ground for utility. It's either barred by the law of the case, and it's futile, or it's futile because it was insufficiently pled. I mean, all Mr.
Well, that's sufficient.
What? Excuse me?
That's not futility. Futility is I'm saying they're two separate things. Insufficient pleading is one thing. Futility is you couldn't possibly sufficiently plead.
I cite law in the brief that says futility can either be insufficiently pled or.
So you're saying you're saying you filed a complaint. Let's say it's the first complaint. How does that work? You say, well, it doesn't state a claim. Well, it's insufficiently pled, therefore it's futile. That's never the analysis for futility. The futility is always, could you sufficiently plead it? And that's the reason why you do not get leave to amend to the complaint.
Well, there's a lot of law cited.
Case law. But presuming my conception of how futility works, what's your argument?
It was certainly futile because of the law of the case argument that I've been.
Well, okay, so what if we don't buy your law of the case argument? Hypothetically speaking, this is an exercise of your oral argument. We explore all options because we want to know all the arguments that could support it or affirmance or not. So what if we don't buy it? What is your futility argument independent of law of the case?
That it was insufficiently pled because, first of all, as Your Honors pointed out to Mr. Brannick during his presentation, the trial court had nothing to go on as to what to determine about the motion to amend. I put the whole colloquy in my brief, the whole passage in the motion to dismiss hearing where O'Doyle's counsel describes what the complaint that he keeps saying that he had at his fingertips said. It's very bare bones, and I also point out in my brief that once again, it's impossible based on the record and what I know about this case that I've been litigating now for 6 years, that there is a assignment of any sort from SunTrust to
Let's
O'Doyle.
start with the basics. It's never been litigated. So someone could, a la television drama regarding legal cases, say, I found the case drafter, here's the assignment. But, you know, they've never alleged that. So is your argument better framed as a preservation argument? In other words, you know, you could amend, you could say, well, you know, it was in the filing cabinet. But the point is, I guess my point is, if we were to write an affirmance, would we say, it's futile because it wasn't sufficiently pled? Or would we say, it wasn't preserved because how is this court supposed to review whether it's futile when all you did is get up there and say some nebulous mumbo jumbo about an assignment and we don't even know whether it's written or implied?
I think each of those points are equally persuasive, as I've outlined in my brief. I think there's a number of problems with what O'Doyle did as just.
Let me ask you, just to do the exercise with this, what's your best case on the denial of the Corey-Tennyson motion for Take 2 amendments?
I don't know if I don't know if I
You
can,
gave us a couple of different theories on why you think that would support, and why you don't think it was an abuse of discretion.
yes.
Tell me what your best case is. Is it that they didn't preserve it because they didn't file a proposed amended complaint? Is it that it was futile because you represented to the court that there was no way legally this could happen? Or was it something else?
Well,
Is it because the complaint, this was the third complaint and 3 strikes you're out and then we strike this?
no, I don't go to the prejudice. It's futility, and I argue violation of the rule on moving to amend that, because there's nothing before the court. Their argument.
Judge waits 20 months to get a pleading, and this is what he gets, something that's unwarranted.
That is correct, Judge Black. As I pointed out in my brief, and what's very interesting, we're sitting here now, over 3 years from the court's appellate decision, and we still don't know, as we sit here today, what the theory really is. And it's an impossible theory, I can assure you, based on what the discovery, and just to follow up on your question, Judge Atkinson, we made requests for production of those documents, and they were never produced by either SunTrust or O'Doyle. So unless somebody didn't produce a document that was requested, there is no written assignment. And the de facto assignment, as I've outlined in my briefing throughout, in the first appeal and this one, an assignment is impossible because of the wording of the lease. An assignment of the rights of SunTrust under the purchase agreement is also impossible. So it's
It's
definitely
possible, it's just we don't have a record, and your position is, since there isn't one, it doesn't exist.
because it doesn't exist. Yes,
That this could happen without the participation of O'Doyle.
Yes.
That's really your argument, isn't it?
that is correct.
With your obvious interest in knocking it down, could you use your best efforts to explain what the de facto assignment theory is?
Yes, and I mean, I'm going to try to describe what I think they're trying to say. They're trying to say that withdrawal letter that was sent, withdrawing, SunTrust withdrew the exercise of its right of refusal 14 months after it exercised it, and even more absurd in a way, after it had already executed a purchase and sale contract with the trust. So how could SunTrust withdraw its right of first refusal that had blossomed, and that's in the brief as well, blossomed already into a purchase and sale agreement? It makes the argument actually even more untenable, because if O'Doyle really got an assignment of SunTrust's right of first refusal that SunTrust had exercised and then entered into a contract and then defaulted on that contract, there is no right of first refusal that could be assigned, even if it was permissible under the lease, and it isn't. The de facto assignment argument to me, if I understand, is when SunTrust withdrew its right of first its exercise of its right of refusal, somehow, by some means, it was a de facto assignment of SunTrust's right to purchase the property. And I make this comment or argument in my brief that it seems like, and I don't ever want to denigrate my opposing counsel, but it seems like O'Doyle has tried to kind of hide the ball on this, because as I said, as we sit here
But
today.
you had the whole big issue of, because the settlement agreement that I think they wouldn't allow the client to tell you that it was confidential, and
Right.
for probably a variety of reasons, nobody was able to elicit whether the settlement agreement covered.
Well, it doesn't. We actually have I got the unredacted version. I didn't have the unredacted version in the first
At
appeal.
least the record that we have, we don't know the answer to that question. And that is a suggestion, it seems to be a suggestion that perhaps the settlement agreement would tie to some sort of settlement. Wrong about
Well,
that?
I don't want to go beyond the record, but I can tell you this.
I don't
SunTrust.
want to go beyond the record either.
Yeah, I firmly believe that there is no plausible way that the de facto assignment theory could ever really be plausibly pled
That sounds like a futility argument.
in good faith. What's that?
So that sounds like a futility argument.
It is. It is a futility argument, and I mentioned that in the brief. I think it's prohibited anyway by the lease, so it couldn't happen legally anyway.
You're about out of time, so.
Thank you for your time.
Let me briefly address law of the case and preservation. As to law of the case, I think we can all agree that the assignment theory was rejected by this court. As Your Honor, Judge Atkinson, I think you put your finger on it. The question is why? Was it rejected on the merits, or was it rejected on the ambush theory? The cases are absolutely clear. The Giuliano case says that you're not bound by something we didn't write about unless it's every possible way that's necessary to the decision. And since you could have ruled on the ambush basis, it's not necessary to the decision. The Dandar case from this court, the Smith case from this court, both of which are cited in the brief, make that crystal clear. So I don't think there can be any question about law of the case. So that brings me back to the preservation argument. To preserve error, we have to make sure that this court has all of the information it needs to make the ruling.
Based on the information, I'm going to cut you off because you have a very short time. Are you saying that it's an Ori tennis presentation of the information we need? And we have all this record, and I suppose it counts all these years. And could you please explain what the de facto assignment theory is?
Wait, I mean, it's not in the record, so we don't know whether it's based on the redacted settlement agreement. We don't know whether it's based on.
Well, I mean, the record, we can take notes of the briefing from the last case, that's all available.
Right.
What's the theory? Because we have to talk about futility. Okay, well,
Well, I think the most likely theory is either one, there's something in that settlement agreement that allows them to step into SunTrust's shoes. Or secondly, there's something about the withdrawal of
What about
their
the
right of
withdrawal?
first refusal that allows them to step
could
in.
give rise to de facto assignment.
Pardon me?
What about the just mere fact of withdrawal of right of your first refusal after it's exercised?
Well, I think that might be.
Assign it to a different party, to a third party person.
But the point I'm making is that at the hearing, he stood up and said, I don't care what the theory of assignment is, whether it's a real assignment, whether it's a de facto
The point
assignment.
that you're saying that we don't know, how are we supposed to review this? How are we supposed to review futility? How can we assign error on an abuse of discretion standard if given the preservation And again, we're bleeding back and forth between futility and
But-
preservation. But how can we assign error to a judge when what was presented doesn't allow us to understand whether it was futile?
Because we have to look at what the judge ruled. The judge didn't rule on any of that stuff. The judge ruled, the judge bought their argument that this was barred by the law of the case. So let's take that off the table. Let's assume that I'm correct and you agree that this is not barred by the law of the case. The judge hasn't reached any of these
Well,
other
if
issues.
you're right about the case, we can put there as far as the basis for reversal, but I think what we're
That's our
focused
point.
on is maybe we might not agree with you about that. And for a variety of different reasons. And so we're confronted with, what about the second piece of your case, which is, do we have enough to reverse?
And there's fault on both sides here. In my opinion, I think they got greedy. They decided to go for a home run on this law of the case theory, and that basically shut down the record without all of these questions being
But
answered.
you're shut down because this Judge Brewer thing brought up. So you're saying, okay, well, the reason why that if we decide that Ori Tennis explanation of the supposed amended complaint was not sufficient for preservation, that we can't review it, why isn't it the fault of the appellant that it was never proffered in our hearing? Or you can file a motion, just file a motion at one point, not, whatever, we'll forget. But, it says, everyone does it.
Because
Motion for leave to amend, here's the attached complaint.
I mean, if you're talking about futility, at that point, all of that was futile, because they said to the court at the hearing, it doesn't matter what the theory of assignment is, all of the assignment theories are barred by the law of case. So at that point in
The judge
time,
said, oh, wait a minute. Now that I read your complaint, maybe it wasn't law of the case after all. But wouldn't that be what you take to preserve it?
And isn't that what the function of a motion for rehearing is to set up a preservation? And that was the question I asked at the
That's-
outset of your argument. That's where the dilemma is here.
The law on what you need to do in a motion for rehearing is pretty clear. If an issue wasn't argued in the main hearing, then to preserve it, and the judge goes off on a new tangent, you've got to raise it in the motion for rehearing. But here, that assignment issue and whether it was law of the case was in fact argued at that first hearing. So yes, it would have been the better practice. There's no question that if I had been the lawyer in this case, you would have seen that amended complaint. But the
Because
question
the
for this
trial court
court,
still had jurisdiction. And you could have made an argument on the Ori Tennis motion for leave to amend that you could convert to a written motion with your rehearing. And it was a fulsome motion for rehearing. So it just
We'll
is,
then respond and that'll conclude our hearing after.
it certainly could have been, but they were facing a judge who had already ruled that, had bought an argument that the assignment issue was gone, period. At that point in time, it didn't really matter what they pled. The assignment issue was gone. And our point is, if you disagree with that, then you have to disagree with the judge's dismissal with prejudice. Thanks for your indulgence, Your Honor.